Now, the state does have a solution for you. Aren't you glad?
Yeah.
Because we've raised the tension level, and now we're going to give you
take a deep breath.
There is a solution. And Judge Wolk, why don't you kind of cover some of this emergency? Actually, I'll cover this when we get to the emergency guardianship stuff, because that's a little different. In Georgia, we have a thing called the doctrine of implied consent. If you are in a car accident, you are rendered unconscious, doctors are permitted to assume that you want them to do everything possible to keep you alive. So that's the doctrine of implied consent. Then there's also a process of involuntary committal. I believe they're called 1013 admissions. Basically, if a doctor, or I think there are a couple of other people that can allege this, allege that you are a danger to yourself or others, they are permitted to hold you in a psychiatric care facility for up to 72 hours. If they want to hold you longer than 72 hours, they have to go before Judge Wolk, or any of the other probate judges that are in that county, and convince the judge that you remain a danger to yourself or others. And then Judge Wolk can order an appropriate length of time to be held. We also have a law here in Georgia, OCGA 3192, which authorizes certain people to consent on behalf of certain other people. And recently that law was amended to include parents and siblings of adults. The question seems to be, though, that only applies in emergency situations. It does not apply to routine care and, non-acute treatment options.
This is where I do this every day. Everything that you guys do every day, I'm sure you'd miss steps and you'd make assumptions that people know what you're talking about. I know what I'm talking about. If I use words or acronyms or things, I want you to say, whoa. There are 4 things that we will be talking about in guardianships. An emergency guardianship over the person, medical care, emergency conservatorship over the property, a permanent guardianship over the person, and a permanent conservatorship over the property, the person and the property. So when you talk about an emergency guardianship and conservatorship, that's one pleading, one thing that you file with us, one starting document. You need 2 people, either 2 family members, a family member, friend, whatever, or a person and a medical provider who can be a doctor, psychologist, or licensed clinical social worker licensed in Georgia, who says, yes, this person needs a guardianship and or a conservatorship, and here's why. In a permanent petition, that process from filing to a hearing, and there's always a hearing, takes approximately 4 to 8 weeks, depending on which court you're in, what time of year it is, how busy the court is, how difficult the scheduling of everything is. But you're looking at a couple of months or less, usually. In an emergency guardianship, it is 3 to 5 business days. So if you file it on Friday, you will have an emergency hearing before the next Friday. And so you are looking at, when you petition and you make your allegations, it is expensive. It's about $600 to file each one, an emergency and or a permanent guardian, or an emergency or a permanent, are each about $600. There is a fee to the probate court for processing it. There is a fee for the court-appointed evaluator, who is also a doctor, psychologist, or licensed clinical social worker licensed under Georgia law. That person will do an independent evaluation. So even if you have gotten your family doctor to say, Johnny needs a guardianship, he's fixing to turn 18, we're still gonna send out an independent doctor. There were too many abuses where people were paying doctors to say things that they wanted them to say. So now there needs to be this independent appointment. We will also appoint the proposed ward, who is, in this circumstance, generalizing your child. We will appoint them a court-appointed attorney. We are appointing them a court-appointed attorney because at the end of the day, it is presumed that we will remove the right to marry, contract, own property, consent to medical treatment, refuse medical treatment, decide where they live, and a number of other things. So they are entitled to representation. If all we're going to do is send you to jail and you can still own your property, get married, and go on Mark's dating websites, then if we're going to appoint you a court-appointed attorney for that, if we're going to take all of these additional rights away from you, we're certainly appropriately going to appoint an attorney for that person in that proceeding. But that is, those fees, $125 and $175, go for those two professionals. So that cost is rolled into that $600 filing fee. The probate court doesn't get the whole $600. But all of that has to happen in an emergency guardianship within the 72 hours. You file, within 72 hours, we have to have an evaluation done of the proposed ward. You can imagine how fun it is to find a doctor when somebody files an emergency on Friday afternoons. We get them evaluated, and then we have a hearing, all within a business week. So it is a very rushed situation for our court, and also for you, because you're going to have to work with the physician or the psychologist to arrange the evaluation and all of that. And this is a doctor who makes a house call for $125, so you can imagine the selection that we have. They're great people who do this out of a passion and a community service, but we are not having folks knocking down our door to do these services for us. Same thing with the attorneys who are making a house visit and coming to a hearing for $175. On a non-emergency basis, you're looking at a couple of months, but you're still looking at all of these pegs having to go into these holes to make sure that we've done everything that we're legally required to do. Then at the end of that, there is a hearing. There will always be a hearing. If you ever get a guardianship without a hearing, we need to know about it because somebody's doing something wrong. And I have actually heard of that once, but we'll not. And sometimes the hearing takes 10 minutes. State your name. What is your relationship to the proposed ward? Please tell me why we're here today. What's going on? What assets does he or she have? Why do you think that they're incapable of managing those assets? Why do you think that they're incapable of managing their health care? What types of behavior have they gone through? Why are you doing this now? Why is this necessary? Have you encountered any difficulties? If you are appointed, what is your plan? You stick in your answers between those questions, and that's a pretty standard, after you, do you solemnly swear or affirm that you will tell the truth, the whole truth, nothing but the truth, so help you God? After you do all that stuff, that's pretty much what a guardianship proceeding is if there's no contest. It doesn't take long. We typically don't bite, and we're trying to accomplish the same goal, which is protecting this person. It gets a little more complicated if there's an objection or if there are some questions about the specifics, and some judges just seem nicer than others. Some of us are a little gruffer. So, but that, from beginning to end, in a simplified Cliff Notes version, is a guardianship.